Hey everyone, welcome back to Exposed. I'm Jim Chapman and we are jumping right into it today. I'm going to start with this. 27 episodes, over 35 hours of content, and I'd hoped that I was done ever saying the name Alex Murdaugh again. But if you listen to episode 27 of the massive Murdoch series I did way back in April 2025, I told you what just happened likely would happen, and that is on May 13th, the South Carolina Supreme Court overturned Alex Murdaugh's murder convictions in the killing of both his wife Maggie and his son Paul. So what happened? What does it mean for the future of these two killings? And does this mean that Alex Murdaugh is getting out of prison? Well, we're going to discuss all of that today, and I'm going to catch you up. So a little refresher for you on where I left off way back in April of 2025. Becky Hill had pleaded guilty to 4 charges, all related to tampering in the Murdoch trial. She was the clerk of court in Colleton County where this high-profile trial took place, and I knew then that that was going to be an issue. And it was at that point that Murdoch's lawyers, of course, they challenged this all the way to the Supreme Court. So when these cases are decided, the Supreme Court does issue a brief, and that brief breaks down essentially why they rendered the verdict they did. Now, I have that brief in front of me. I'm going to cover that today, and I'm going to give you the details you can't get from a 5-minute blurb on Fox News, right? So let's get into it, and it starts off. For 6 weeks in early 2023, the eyes of the nation focused on Colleton County, where the state prosecuted notorious former attorney Richard Alexander Murdoch for the murders of his wife Maggie and his son Paul. Both the state and Murdoch's defense skillfully presented their cases to the jury as the trial court presided over this complicated and high-profile matter. However, their efforts were in vain because Colleton County Clerk of Court Becky Hill placed her fingers on the scales of justice, thereby denying Murdoch his right to a fair trial by an impartial jury. Our system provides, indeed demands, that every person is entitled to a fair trial, which includes an impartial jury, untainted by external forces bent on influencing the jury toward a biased verdict. Although we are aware of the time, money, and effort expended in this lengthy trial, we have no choice but to reverse the denial of Murdoch's motion for a new trial due to Hill's improper external influences on the jury and remand for a new trial. Because we order a new trial on these bases, it is not necessary that we review every evidentiary issue Murdoch raises on his appeal. However, we address the admissibility of Murdoch's financial crimes to offer guidance on this thorny issue to the trial court on remand. Then it goes into the facts and procedural background. Murdoch was convicted on March 2nd of 2023 of the murders of his wife Margaret Murdoch and his son Paul Murdoch, as well as 2 counts of possession of a weapon during the commission of a crime. The trial court, Judge Newman, sentenced him to life in prison while his direct appeal on these convictions was pending at the Court of Appeals. Murdoch filed a motion to hold an appeal in abeyance to allow him to file a motion for a new trial. The Court of Appeals granted this motion. On October 27th, 2023, Murdoch moved for a new trial, asserting Hill tampered with the jury by advising it not to believe Murdoch's testimony and other defense evidence. She also pressured it to reach a quick guilty verdict, and she also misrepresented information to the trial court in an attempt to have the court remove a juror she believed to favor the defense, and that was the egg juror that I told you about. He attached affidavits from several jurors to support that motion, and Chief Justice Betty appointed former Chief Justice Toll to preside over this motion as the trial court judge had recused himself. The post-trial court conducted a hearing of this motion on January 26th and 29th of 2024. During the hearing, the post-trial court asked each juror if the guilty verdict was an accurate statement about their verdict at the time. and also asked whether their verdict was based entirely on testimony, evidence, and the law presented in the case. Also, it was asked whether they heard Hill make any comment about the case before the verdict, and lastly, whether their verdict was influenced in any way by communications with Hill. Juror X, who testified on the first day of the hearing, acknowledged Hill say before Murdoch's testimony, quote, looks like the defendant is going to testify. This is an epic day, in that it was rare for a defendant to testify. Juror X said that these statements did not impact the verdict. Juror Z, who submitted one of the affidavits Murdoch attached to his motion for a new trial, was the first juror to testify on the second hearing date. When asked whether she heard Hill make any comments about the case, Juror Z responded that Hill said, quote, watch his actions and watch him closely. Juror Z added that Hill said it more, but she couldn't remember anything else. Juror Z explained Hill's statements influenced her finding Murdoch guilty because, quote, to me, it felt like she made it seem like he was already guilty. At the state's request, the post-trial court questioned Juror Z about her affidavit, addressing each paragraph in turn. Juror Z's affidavit gave a more detailed recitation of Hill's comments. And it goes on to say, after reviewing the affidavit, the post-trial court questioned Juror Z. Quote, I asked you previously, was your verdict on March 2nd, 2023 influenced in any way by communications from Becky Hill, clerk of court? You answered the question, yes, in light of what you said in the affidavit, which is, quote, I had questions about his guilt, but voted guilty because I felt pressure by other jurors. Is that answer that I just read you more accurate than the statement you felt? And Juror Z answered affirmatively. The post-trial court then asked if she stood by the affidavit, and she said yes. Juror Z subsequently submitted an affidavit to clarify her testimony, in which she explained she felt influenced to find Murdoch guilty by Hill's remarks before she entered the courtroom and once deliberations began. She felt additional pressure from other jurors to reach a guilty verdict. Although the post-trial court did not admit this affidavit, it accepted it as a proffer. Thus, the affidavit is part of the record before this court. Juror P testified that on the day Murdoch was supposed to take the stand, Hill made a comment to, quote, watch his body language. He denied Hill's comments influenced him in any way. The remaining jurors testified they did not hear Hill make any comments about the case, and they were not influenced by any comments Hill made. Following the jurors' testimony, the state called Hill as a witness. Although Hill denied making most of the comments the jurors related, she did admit that on the day Murdoch testified and within earshot of some jurors, she spoke to the bailiff about Murdoch's decision to testify. She also stated that she gave the jurors, quote, a little talk, instructing them to pay attention and that it was a big day. She denied attempting to influence the jury. In discussing her book, Behind the Doors of Justice, Hill claimed literary license to explain some of the more dramatic passages. She denied wanting a guilty verdict because it would sell more books, claiming the outcome of the trial did not matter to her, but she acknowledged that she felt like Murdoch was guilty. The post-trial court also questioned Hill about the favor she granted the media. Hill denied allowing the press to view the exhibits, including the sealed exhibits. However, she did plead guilty to perjury stemming from this denial. Although the post-trial court limited discussion on juror 785, whom the trial court dismissed the day deliberations began, that's the egg juror, for allegedly discussing the case with a third party, it allowed Murdoch to question Hill about bringing to the trial court's attention social media posts that Hill mistakenly believed were from the egg juror's ex-husband. Hill claimed the juror was very talkative while Hill walked her through the trial court's chambers and volunteered that there were restraining orders on her ex-husband when they divorced. In response to the post-trial court's questioning, Hill continued to deny initiating or engaging that juror in discussion. And it goes through, y'all, several, I would say probably 15 pages of other examples. I'm not going to go through all that. And the reason that I'm not going to do that is, look, this lady's already been found guilty. There's no doubt in anybody's mind that she influenced this jury. But I'm also going to get into the part that isn't being covered very heavily anywhere else, and that is the financial crimes and how they played a part in Murdoch's guilty sentencing, in this case being overturned. And we'll get into that. It says, because we order a new trial based on Hill's improper influence on the jury on appeal from the order denying Murdoch's motion for a new trial, it is not necessary we address the evidentiary issues Murdoch raised on appeal from his convictions and sentences. We elect, however, to offer the trial court on remand the following guidance regarding admissibility of evidence of Murdoch's financial crimes. And if you'll remember, he was stealing from every client he had, and we went over all that. I won't rehash it, but I'll tell you what they said about it. At the time of the trial, Murdoch had been accused of and indicted for numerous financial crimes. During his testimony before the jury, Murdoch admitted he had committed the financial crimes, although he had not at the time been convicted of anything. After trial, he pled guilty to the financial crimes in both state and federal court. He was sentenced to concurrent 27 years in state prison and 40 years in federal prison. So that means those sentences are going to be served at the same time. So he essentially got 40 years because the federal charge is a longer amount of time than the state charge. And it's interesting, when you're charged in a federal court with a crime, you don't get any option for parole. You got to serve 85% of that sentence. And the reason it's not 100% is you get some good time mixed in there, assuming he was good and he didn't get in any fights, anything like that. He's going to serve at least 85%, but more on that in a little while. The state sought to admit evidence of these financial crimes during Murdaugh's murder trial for the purpose of showing his motive for committing the murders. The state filed a pretrial motion in which it argued the evidence demonstrated, quote, Murdaugh accrued substantial debt over the period of years, and to cover these debts began engaging in illicit financial crimes involving the theft and misappropriation of money from his clients and his own firm. The state emphasized that several series of events unfolding in the weeks and days leading up to the murders threatened to expose Murdaugh's financial crimes. The state wrote in its motion, quote, all of these factors start to converge on June 7th, 2021. The date of the murders. The state explained its motive theory, quote, the murders served as Murdaugh's means to shift the focus away from himself and buy himself some more time to try and prevent his financial crime from being uncovered. The state also stressed Murdoch's attempts to cover his financial misdeeds after the murders to support its theory of motive. Murdaugh filed a memo arguing the financial crime evidence should be excluded, and it listed some rules there of why. And it said the trial court conducted a lengthy pretrial hearing but declined to rule on the admissibility of the financial crime evidence at the time. During various breaks in the course of the trial, the state presented testimony of 8 witnesses regarding Murdoch's financial crimes outside the presence of the jury. After hearing this testimony and the arguments on both sides, the trial court found, quote, all evidence of financial crime that may likely have led to a motive or lend itself to a motive for the crime committed was admissible. The trial court stated the jury was entitled to consider whether the apparent desperation of Mr. Murdoch because of his dire financial situation, threats of being exposed for committing the crimes for which he was later charged, that resulted in the commission of the alleged crimes. The trial court also found this evidence of other crimes is admissible as it does not suggest to the jury that the defendant has a tendency to commit murder. I specifically find that these crimes will not lure the jury into declaring guilt on a different ground than specific charges. The trial court found the evidence had sufficient probative value and was not substantially outweighed by any danger of unfair prejudice. The trial court issued a written order setting forth its ruling. The state presented testimony to the jury from 8 witnesses who testified earlier, along with 2 additional witnesses. Through these witnesses, the state proved Murdoch committed wide-ranging financial crimes over numerous years in several general categories, including the following. 1. Murdaugh stole money from his clients by billing personal expenses to them under the guise of these expenses being costs associated with their cases. 2. Murdaugh stole money from his law firm by instructing law firm employees to make checks payable to, quote, Palmetto State Bank, whose then CEO, Russell Lafitte, enabled Murdoch to convert the funds for his personal use. 3. Murdoch stole money from his clients and his law firm by instructing law firm employees to make checks payable to Forge, a fake account Murdoch created to imitate the legitimate Forge Consulting LLC firm that Murdoch then deposited and used for personal expenses. And 4, Murdoch stole money from Tony Satterfield by filing an insurance claim in relation to his mother Gloria Satterfield's death and collecting the insurance proceeds for personal use instead of providing the proceeds to Tony and Gloria's other son. The state also presented evidence to the jury that Murdoch's years of stealing money in these ways was about to be exposed. For example, law firm employees testified they asked Murdoch on at least 2 occasions in the weeks leading up to the murders about discrepancies in his financial disbursement documents in individual cases. Jeannie Seckinger, the firm's chief financial officer, testified she confronted Murdoch on the morning of the murders, stating, quote, "I have a reason to believe that you received monies directly to you, and you need to prove to me that you did not." Other evidence includes Seckinger was referring to $792,000 in missing attorney's fees the firm was supposed to have received from Murdoch's co-counsel Chris Wilson. The state also presented evidence from Mark Tinsley, the attorney representing the family of the young women who died in the boat wreck, had scheduled a motion hearing for 3 days after the murders in which Tinsley sought to compel Murdoch to disclose his detailed financial records. Murdoch challenged the admissibility of evidence of his financial crimes, and it lists some rules, some reasons for him doing that, etc. Goes on to say, as to Murdoch's relevance objection, the state argues that because Murdoch was charged with murdering his wife and son, quote, seemingly inexplicable conduct when standing alone, it was important that it offer evidence to explain why he did it. The state also argues Murdoch himself placed the issue of motive front and center through his own actions by suggesting to officers who arrived at Moselle on June 7th that, quote, the killer's motive stemmed from the boat wreck. We agree with the state that evidence of Murdoch's financial crimes made the state's theory of motive more probable. Thus, we find the trial court acted within its discretion in finding the financial crime evidence was relevant and admissible. The more difficult question is whether the trial court should have excluded all or some of the financial crime evidence. We address this question as 2 distinct categories of issue. The first of these categories, whether the trial court should have excluded all the financial crime evidence, is a point on which not all members of the court would have ruled the same way we have been in the trial court. We agree, however, this decision was within the discretion of the trial court under facts and circumstances that existed in the Murdoch murder trial. As to the second category, we will address whether the trial court should have restricted to the extent the state was allowed to present this evidence. That is, whether the trial court should have excluded some of the evidence. We unanimously hold the trial court allowed the state to go too far, too long, and too deep into the aspects of Murdoch's financial crimes that were not probative to the state's theory of motive, which gave rise to considerable danger of unfair prejudice and therefore should have been excluded. As to whether the trial court should have excluded all evidence of Murdoch's financial crimes, we have discussed the principles that apply when a trial court is asked to exclude evidence of other crimes in numerous cases. And they list some of those cases where all of this shit kind of came up. Goes on to say, as to Rule 403, the trial court's balanced and probative rule of evidence against its potential for unfair prejudice and concluded the probative value was not substantially outweighed by any unfair prejudice. The trial court specifically found Murdoch's commission of the financial crimes does not suggest to the jury the defendant has a tendency to commit murder. So basically what they're saying there is just because you're stealing a shit pile of money and you're a piece of shit for stealing money from clients and your own law firm and things like that doesn't necessarily make you a murderer. Now, to me, it does kind of give you a motive when you have that much pressure on you, but it doesn't necessarily make you a murderer, and that is what they're trying to say there. It also goes on to say, we emphasize the trial court should have limited the state's presentation of this evidence. We illustrate this point with an example from the direct examination of Tony Satterfield. Quote, the state, why were you the personal representative and not your brother? Satterfield, because my brother is a vulnerable adult and has a disability. Court, can you repeat those words for me? Satterfield, that's my brother. He's a vulnerable adult and he's not able to function as a normal human being to deal with stuff like that. State, he's a vulnerable adult. Satterfield, yes. The Supreme Court said this particular testimony had zero probative value as to Murdaugh's motive for the murders and obviously high potential for unfair prejudice as it portrays Murdoch as a man who preys on vulnerable victims. And I would agree with that as far as what they're saying there, because you can see in that little quote that they took out, it was really hammered down. Hey, your brother wasn't the one representing you in this case that Murdoch had accepted and was defending you on because he has some issues, obviously. They were wanting the jurors kind of to feel sorry and see how much of a piece of shit that Murdoch was to prey on people with disabilities. So I would agree with them there that might be dangerous as far as unfair prejudice against the defense. It goes on to say much of the additional details the state presented as to Murdoch's financial crimes had little or no probative value for the purpose of establishing Murdoch's motive. The state's theory of motive centers on the point that his financial crimes were about to be exposed and he needed time. The fact that he committed some of these crimes against a vulnerable adult adds nothing to that theory, as I just told you. To the extent many similar details may have minimal probative value, that value is substantially outweighed by the unfairly prejudicial sympathy the jury was likely to feel toward the victim. By our calculation, the state spent a total of 12 and a half hours of actual testimony before the jury over 10 days of trial to introduce evidence related to Murdoch's financial crimes. We are convinced the state could have effectively presented evidence to support his motive theory in a fraction of that time. So they're saying there that the state just overblew it to the point, 10 and a half hours just on his financial crimes, rather 12 and a half hours just on his financial crimes. They're saying, hey, you could have talked about that for 3 hours and got your point across. And that's probably true. Goes on to say, by holding the trial court in this case acted within its discretion in admitting some evidence of Murdoch's financial crimes, we certainly do not intend to require the evidence be admitted on retrial. As is often in this case, the facts and circumstances on retrial may be different from those presented in the initial trial. Thus, the trial court on remand must do as the trial court did here, carefully and thoughtfully apply correct principles of law to the facts and circumstances before it. We do intend to require, however, that if the trial court decides to admit evidence of Murdoch's financial crimes on retrial, the state must complete its introduction of that evidence efficiently without the lengthy presentation of inflammatory details with little or no probative value that was permitted in the first trial. And then it goes into the conclusion, and it goes on to say, as the Fourth Circuit declared, it serves to protect the right of a fair trial by an impartial jury for all defendants. Here, Hill, the Colleton County Clerk of Court, egregiously attacked Murdoch's credibility and his defense, thus triggering a presumption of prejudice, which the state was unable to rebut. As noted at the outset, Hill's shocking jury interference was accomplished outside the presence and knowledge of the outstanding trial judge and superbly competent and professional counsel for the state and the defense. We are accordingly constrained to reverse the post-trial court's denial of Murdoch's motion and remand for a new trial consistent with this opinion. And it is very important to note that every Supreme Court justice agreed on this one. Very important to note. So to sum that up, the reasons that Alex Murdaugh is getting a new trial, and this one is completely at this point thrown out as if it never occurred, is because of Becky Hill primarily. And she's the main cause of this. But even taking her out, they're also saying there was too much prejudice placed on him with the financial crime aspect and how it contributed to the killings. All of them agreed. And I'll tell you what, I agree with 3/4 of it. I definitely agree, and I told you this a freaking year ago, this was not going to hold up. He was going to end up getting a new trial. And the way I knew that was because of Becky Hill. I question the financial crimes and the amount of time they spent on it, but I don't know if he would have necessarily gotten a new trial just based off of that. But the Becky Hill thing alone is enough. She definitely tampered here. She's been found guilty of it. And look, it doesn't matter if you're guilty or innocent. Everyone in the entire United States, it should be that way everywhere in the world, but it's not. But right here in this country, if you're charged with a crime, you have a right to a fair trial. And believe me, there's people out there that didn't do shit that are sitting in jail right now that didn't get fair trials. Now, all that being said, I don't think that the Supreme Court in South Carolina thinks he's innocent. I think they know he's guilty, but they're saying, hey, it doesn't matter who you are, you got to follow the rules, and that includes the state as well. This comes out, it makes all the news. Everybody everywhere freaking out over Murdoch's trial verdicts getting thrown out, at least in the murder cases of his wife and son. I'm telling you, I personally got, and thank y'all so much for this because I love it when y'all do this, but I got probably 30 messages through Facebook in a matter of an hour saying, hey, did you see this? I sure did. And I definitely planned on doing some episodes on it, or at least this one episode. But there you have it. So for the record, I totally agree with this one. Now, doesn't mean, obviously, I think Murdoch is innocent. I believe in the rule of law, and I believe in this country, and you can't get a fair trial when the damn clerk of court tampers with the jury like Becky Hill did. So a few questions you may have at the end of this one as I wrap it up. First, does this mean Alex Murdaugh is getting out of jail? And the answer to that is no. Even without this case, y'all, he was convicted in federal court, as I told you earlier, for his financial crimes, and he was sentenced to 40 years in prison federally, 27 years in state prison, but they're running concurrent, so 40 years essentially. There is no parole, as I said, and at a minimum, he's going to have to serve 85% of that. So if you're curious, let's say he got all the good time that you could get in federal prison. He's going to serve till at least a release date of 2064. It's a long time. He's currently 57 years old. So the youngest he will be released from prison just for the financial crimes, he'll be 95 years old. And the chances of him living to 95 are almost zero, especially locked up in prison like that. It happens, but it's extremely rare. Make him 1% of the entire world. Now, another question I had is, are they going to retry him? And they say they will. Now, this case, y'all, was all circumstantial, this murder case with Maggie and Paul. And what I mean by that is they don't have a video of him doing it. They do have a video of him talking when he said he wasn't at the kennels. Remember that. If you don't, go back and listen. But remember, Paul Murdoch was making a TikTok and you could hear Alex Murdaugh in the background. And he said he wasn't at those kennels. And he tried to explain it away later on when he took the stand. But they do have that. But of course, they have no murder video or anything of that nature. And outside of the financial crimes, which I don't know if they're going to introduce in a new trial, the Supreme Court seems to recommend they do not do that. Outside of the financial crimes, they're going to struggle to find a real motive on this one. That being said, they're saying, hell yeah, we're going to retry it. But keep in mind, y'all, you have to get 12 people to agree that he killed his wife and son. 12 people. That's no easy task, even when you have a lot of physical evidence. They have no physical evidence. Zero. Not saying he won't be found guilty. I don't know. I'm just saying they are going to have a hell of a road stacked up against them in that second trial. But again, he's in jail till he's 95 anyway. But we'll see if they actually have a trial there. You may be curious of how much the state of South Carolina actually spent on this first trial. I know I was. Well, get this. It was 6 weeks long. It included 75 witnesses, and it cost $500,000 to prosecute this case. I actually thought it would be more, but that's plenty of money, right? Especially keep in mind when the whole case got thrown out. So that $500,000 was pissed away because of the clerk of court. Now, Alex Murdaugh spent $700,000 on his defense team. You may say, well, where did he get that money from? Well, he had a 401k that his attorneys got the court to agree, hey, we're going to take this 401k and that's going to be y'all's legal fees. And so $700,000 was spent there. You may be asking, can Murdoch sue Becky Hill civilly for tampering in that case? And the answer to that is yes, absolutely. He can do that. Not only can he do that, he will do that. You can bet on that. His defense team's going to want to get paid to retry this case as well if it goes to retrial, which I think it will. And that's going to be a way of them getting money, right? They're going to sue Becky Hill for tampering in his case. And I'm sure she had some sort of retirement or something. So look for that. Incidentally, Becky Hill is not in jail. She was found guilty of all these things, but she never got sentenced to actual jail time in jail. So that's just incidentally something on the side there for you. Now, I'm sure there's going to be more to come on this case. And of course, I'll keep you informed. And if it becomes necessary to do a full episode on it, I will do that at that point. But for now, there you have it. Murdoch, yes, that whole case has been thrown out. So at this point, he is not guilty of killing his wife and son, at least in the eyes of the court. However, he is still in jail, and he will always be in jail at least until the age of 95, which is a life sentence in my eyes anyway, which is what he was serving for these charges. But if he did indeed kill him, he needs to have that put on his name, if you will. And so we'll see what occurs there. Thank you so much for listening. Can't tell you how much I appreciate each and every one of you. Incidentally, for top tier Patreon members, you should be getting, I've mailed them all out this past week. So this week that you're listening to this episode or the early part of next week, everybody should have their quarterly gift. Let me know what you think about it. I put a little thought into that one, and I hope you like it. Until next time, for Exposed Scandalous Files of the Elite, I'm your host, Jim Chapman. Much love.